Imagine you are running a 100-meter race. If someone has a head start of 10 meters, do you think that's equal? Is that fair competition? No, right? So you need a referee who can ensure that all racers start from the same point. And the same is the case with companies as well. There are some companies which can become too big and start to make the market unfair for new competitors to emerge. This is where competition law, or antitrust laws as they are called in the US, comes into picture. They exist to prevent these kinds of unfair practices in the businesses. They stop companies from crushing small ones, raising prices unfairly, or working together in secret to cheat customers. Going into the history of competition law a bit, where does the term antitrust come from? Back in the 1800s in the US, giant corporations called trusts controlled entire industries like oil, steel, and railroads. A trust was basically a legal construct by which these business people arranged their holdings. The first such trust is believed to have been created in 1882 by John D. Rockefeller's Standard Oil. Yes, he is the person in whose name a lot of buildings in the US are still named because, well, he sponsored them with his money. You will find his name in multiple TV shows and movies as well. Just to put his net worth in context today, some estimates suggest that he would have been worth more than 600 billion US dollars, which is way richer than the two richest men combined as well. Effectively, the owners of oil producing companies transferred their ownership rights to an entity called a trust. To be fair, they didn't always want to do it, but they had to, considering the power that Rockefeller exerted in the economy. The rich businessmen supported the government, and the political parties and government in return supported the businessmen. This is what is known as crony capitalism, which was a huge problem in the US back then. To give an example, the railways gave money to Rockefeller because Standard Oil transported more goods through the railways, and in turn they wanted to help his business. Now, once these companies got transferred to the trust of Standard Oil, some companies were shut down by the board of trustees who ran the trust corporation and made decisions, with Rockefeller and other influential people controlling the decisions of these trusts most of the times. They eliminated competition ruthlessly and controlled about 90% of the market. Eventually, the government stepped in to break these trusts down because they were getting too powerful and out of hand. And that is how antitrust laws were born. A senator from the US, Senator John Sherman, chaired the committee for making this law, and the world's first competition law was passed, the Sherman Act of 1890, which is still operational today. Now let's talk about what these laws actually do. If you see the Competition Act, it covers three broad areas. First is combination control. Combination is nothing but mergers, acquisitions, and amalgamation of different companies, and that is called a combination. This combination could cause an appreciable adverse effect on competition. So any adverse effect on competition in India is regulated by the Competition Commission of India, which is the CCI. However, regarding combination control by the Competition Commission of India, the CCI has not rejected any combination till 2025 and has only requested for a change in about 3% of the combinations which have been proposed before it. However, big corporations can falter badly if their combinations keep getting rejected. For example, Illumina is a company in the US which makes specialized machines to read the code of DNA, basically meant for genetic sequencing. Multiple times have their mergers failed to materialize because there were apprehensions by the US regulators of innovation in the field of genetic sequencing getting reduced. When they announced the mergers and acquisitions, you can see the excitement in the market because the share price of Illumina rose like anything. However, once they were rejected, the stock has recently gotten punished brutally and it has went down a lot as well. The second purpose that the competition authority in a country aims to achieve is preventing the abuse of dominance. Now, if a player is already dominant in a particular market, they shouldn't abuse their position. It is important to remember that just being dominant is not the problem. A player can have a larger share in a particular market, like Google has in the case of search engines. However, utilizing that share for exploiting your customers or your competitors, that is the problem. For example, Google and Apple have had dominance in the App Store market because people buy phones which are operating on either iOS, which is Apple's operating system, or Android, which is Google's operating system. Now, once these people buy the phones, Play Store and the App Store of Apple are installed in their phones automatically. And as a result of that, people do not want to go through the hassle and download any other app store. And you will be surprised to know that actually a lot of the mobile phone makers, they have their own app stores from which you can download literally the same apps, but none of us do. As a result of that, Google and Apple charge really high commissions on any in-app purchases from any app that is downloaded through the Google Play Store or the Apple Store. Moreover, they also restrict alternate payment systems, and there are multiple such allegations which competition authorities throughout the world have leveled against them. Thus, lawmakers have intervened to prevent them from abusing this position. Now, coming to the third purpose of competition authorities. The third category basically deals with anti-competitive agreements. So, any kind of agreement which basically hinders competition in the market is considered to be bad. One such example can be cartelization, or multiple people agreeing, coming together and fixing the prices in a market. The Competition Commission of India had passed a historic order against cement companies which were using the Cement Manufacturers Association and its meetings to fix prices, which effectively goes against the spirit of competition itself. Thus, the authorities always try to control such agreements and regulate competition. These are the broad three areas, and how are they related to mergers, acquisitions, or what kind of litigation happens before the Competition Commission and NCLAT. All that we'll delve into a bit deeper when we are dealing with that particular topic.